Mr. Michael Boozer, who joined the court in 2005. My name is Kim R. Schroeder. I will serve as the presiding judge. Predominantly, my job will be to keep time and kind of organize the hearing. I joined the court in 2013, previously living in Hugoton, Kansas. With that, counsel, I would ask for you to identify yourselves, and then we'll proceed with the first hearing this morning.
I guess we'll do it Supreme Court style. May it please the court, Patrick Dunn, Deputy Appellate Defender, here today on behalf of Boniface Wabuyabo.
And may it please the court, Plaintiff Appellee, the state of Kansas, appears by Kendall Kout, Assistant District Attorney, and I was not on the brief, so my bar number is 27221.
Thank you, counsel. As a brief overlay, the first case on our docket this morning for this session of the Kansas Court of Appeals is State of Kansas versus Boniface Wabuyabo. Our case number is 120,456. Mr. Wabuyabo has been convicted of reckless aggravated battery in Johnson County, Kansas, and now appeals, claiming that his Miranda rights were violated and that the law enforcement officers used improper coercive techniques to obtain a confession. With that overlay, counsel, I will give you a few extra minutes this morning to lay any facts that you would like to put forth for the benefit of the parties who may be listening who do not have the benefit of the briefs. So with that, I have this down for a 15-minute argument. Mr. Kout, you have the floor.
And may it please the court, Judge, and I just want to be clear, should Mr. Dunn be going first, given that he is the appellant?
Oh, I'm sorry. I messed up there. Yes, Mr. Dunn can go first, and that makes full sense. Mr. Dunn, would you like to reserve any time for rebuttal?
Yes, may it please the court, Patrick Dunn, Deputy Appellate Defender, here today on behalf of Mr. Wabuyabo. May I have 3 minutes for rebuttal, please?
You may, and proceed.
And I'm going to be flying a little bit by the seat of my pants on the facts. I was proceeding under the normal situation where the court is familiar, but I will do my best to give a brief overview for those listening. Before I do so, just for housekeeping, as the court pointed out, I'm going to actually proceed with my argument as the court pointed out and go ahead and submit issue 3 on the brief. But I just wanted to go ahead and clarify that before I got started. In this case, this is a case involving Mr. Wabuyabo and his spouse were both caregivers at nursing home facilities and worked opposite hours in Johnson County, raising their they had 3 older children and 1 infant, BBW. BBW was 6 or 8 weeks old. I can't recall exactly. But they were both, Mr. Wabuyabo and his spouse were both Kenyan immigrants. And on the day of the event in question, Mr. Wabuyabo had come home that morning after working the night shift at the nursing home. And his wife, Rose, had gone to the nursing home for work. That morning, they bathed the child and I believe gave a ritualistic first haircut, which is apparently some sort of significant ritual in their particular cultural background. And then subsequently, Mr. Wabuyabo sat down to take a nap. Later on in the day, approximately 5 o'clock, I think, Mr. Wabuyabo was having problems with the baby, who was crying unconsolably. After about 2 hours, I believe, he couldn't get the baby to eat, and the baby continued to cry. So he called his wife, and then 911. Police and paramedics subsequently took the child to Children's Mercy, and the child suffered head injuries, significant head injuries. During that time, police in conjunction with doctors, developed their theory, and they believed that the injuries were the result of head trauma, which apparently used to be called shaken baby type syndrome. During that time, after another day, authorities, Child Protective Services came and took Mr. Wabuyabo's children from him into custody. At that point, Detective McMillan had been contacted Mr. Wabuyabo to try and get basically incriminating statements out of him. They arranged for an interview the following day, and the subject and what transpired at those interviews, which ultimately resulted, although Mr. Wabuyabo didn't say exactly what Mr. McMillan hoped, at the conclusion of the interview, he said, fine. He ultimately said, fine, I accept responsibility. And this was after threats that this was the only way to help the baby, and it was the only way his children could be reunited with each other, or possibly ever with their mother. So with that overview, I'd like to go ahead and move into the first issue.
Thank you, Counsel.
So the first issue involves the fact that Detective McMillan never gave Mr. Wabuyabo his rights under Miranda v. Arizona. Miranda is only required in the situation of a custodial interrogation. Each of those are terms of art. An interrogation or statements constitutes statements or acts designed to elicit incriminating information. The state has never disputed that this was an interrogation. This whole situation was clearly designed. Detective McMillan wanted to get a confession from Mr. Wabuyabo. So the real question here is whether the situation was custodial. And with that, I was going to move into the 8 non-exclusive factors that our Supreme Court has set forth for determining whether the situation was custodial. And in weighing these, we look at these under a totality of circumstances type analysis. The first factor is the time and place of the interrogation. The interrogation took place at 9 o'clock in the morning inside the Olathe Police Station. And we think this is a very, very significant factor in as how it happened. Although Mr. Wabuyabo was driven to the police station by his wife, he was dropped off in the public area of the lobby. At that point, that's when, as I was thinking about this last night, it reminded me a lot of the old Get Smart TV show from the 60s. And I guess, showing my age, for younger people, I guess Steve Carell did a movie of it later. But in the beginning, he goes through all those halls as the theme song drones and drones on. That's kind of what happened here. This was a secure facility. Detective McMillan testified that it took a couple of 100 yards to get to the interrogation room, and it required at least 3 secured doors using a key card to get through. So for context, that's more than 2 football fields. So Arrowhead Stadium, 2 of those to get to where in a secure facility, the interrogation actually took place. Although in certain situations you would think, oh, he just went to the police station on his own and was interviewed. Yeah, that sounds like that's that's not a big deal. But when you're stuck at the mercy of the person who took you there through these secured doors, there was no way, if Mr. Wabuyabo said, I want to leave now, that would have been allowed to get up and just walk out. First of all, it wouldn't have been possible. There were these 3 secured doors. And even if he somehow had a breadcrumb trail to get out of this 200-yard labyrinth to get through, it it isn't realistic to think that that was possible. So we think that this was a very significant factor. Next,
Counsel, does the facts reflect that the doors were locked on both ways, or just locked as to getting access deeper into the Olathe Police Department?
in all honesty, I can't tell you. I only know that they required a key card getting down. There wasn't a lot of discussion about leaving, so I just don't have that information. So I'm guessing that wasn't in there. Just in all candor to the court. Next, the second factor is the duration of the interview. This was 2 hours. Although, admittedly, some interrogations have gone longer. This wasn't a situation where there are a lot of breaks, as there are in most of those other long type interviews. This was 2 hours, very intense grilling, yelling, cursing, threats by Mr. McMillan. So we believe this also weighs. The next factor is the number of law enforcement present. Inside the actual interrogation room was only Detective McMillan. However, during that interview, he made clear that there were other people watching the interrogation from his office. And at another point, another officer came in and had Mr. Wabuyabo take a PBT because they suspected he was under the influence. So I think it was reasonable to assume, also considering the fact that he was deep in the heart of the Olathe Police Department, that he was aware of a significant number of law enforcement officers. So we think this factor also weighs. The next factor is the conduct of the officer, and we'll also look at the conduct of the person interrogated. And right off the bat, we have to acknowledge that Detective McMillan tried to invoke, sort of magic words to try and render all of his subsequent conduct, try and make you ignore all the rest of his subsequent conduct. The magic words were, "You're not under arrest right now. You're here voluntarily, and you would not be arrested at the conclusion of their talk. You could leave on your own, and you didn't have to speak if you didn't want to." Now that took 19 seconds. If you look at the video in State's Exhibit 1. So we have 19 seconds of 2 hours where that's supposed to cover all of that 2 hours of conduct. And the reality of what was going on is significantly different. If we look at what Detective McMillan did, he yelled, he screamed at him, told him he wanted to tell him the damn truth. Throughout, it was highly aggressive. One of the biggest problems with everything, which also weighs heavily into the second issue, is the use of Mr. Wabuyabo's family. First, he attempted to mislead Mr. Wabuyabo and telling him they somehow needed him to confess so they could treat BBW. That simply wasn't true. Mr. BBW was never in any mortal danger. The doctors had already begun treatment. It wouldn't have made a difference of anything that he had said. So he lied to him there. Then he proceeded, and this is where the really egregious conduct comes in, and to tell him that your kids have been taken away. We don't know if they're together. We don't know if they're ever going to be together. The only way you can help them is to tell us what happened. That's the only hope they have of ever even being reunited with their mother again. And this is something that that courts from the United States Supreme Court all the way down to this court and the Kansas Supreme Court have said, you cannot threaten to make someone confess to something under pressure that their kids will be taken away.
Mr. Dunn, you've reviewed the tape of the interview, have you not?
Yes.
And just give me a rough ballpark estimate. Where does the interview become intense with the statements about the children or raising the voice, some of the profanity? Does that happen the last hour? Does it last half hour? Does it go throughout? Does it permeate the entire tape? I'm looking for a ballpark here.
Well, when he started talking about the treatment, that was less than 10 minutes into the interview. The yelling, he started yelling at just before 10 minutes also at 9 minutes 50, or actually these are hours, I'm sorry. It was about 40 minutes in, I think, when he began yelling at him. It was 10 minutes in, 20 minutes in, 40 minutes in, and then at the very end where they kept talking about the treatment. It was 50 minutes in approximately when he started yelling at him. Custody discussions happened at 35 minutes in, 37 minutes in, 39 minutes in, and 40 minutes in.
Okay.
So
Thank
sorry,
you.
I had to look that up. And again, it was at an hour and 15 minutes in when finally Mr. Wabuyabo said, "Let me accept, cut this story short, just let me accept, that's all."
Thank you.
So having talked about that factor, moving into the fifth factor, physical restraint or drawn firearms. Mr. Wabuyabo was not physically restrained. However, Detective McMillan was armed with his service weapon at the time, although admittedly, it wasn't pointed at him. The sixth factor, whether the person being questioned was a suspect or a witness, McMillan freely admitted that he was a suspect. The seventh factor, whether he was escorted by officers to the interrogation location, he was driven there, but that really, again, it comes to what I was talking about before. There's a big difference between being driven and speaking to an officer in the lobby versus being dropped off, having your only ride you have to call, and then being taken 2 football fields in through secured doors. So we think this factor also weighs in his favor. And then finally, the interrogation result, whether he was allowed to leave, detained, or arrested. Now, the interview terminated around 11 o'clock. That's an important time to remember because when he asked if he could leave, asked if he could, they were going to talk to his wife. He said, "We'll deal with that downstairs. The video ends." It's not clear how much longer Mr. Wabuyabo was detained. And we have to admit, he wasn't arrested at 11 o'clock in the morning. And the state brings that up, but they ignore the fact that he was arrested at 11:45 a.m. that morning. So it was less than 45 minutes after the interview, the interrogation, I should say, that he was arrested. So really, it was custodial. They were just trying to go through motions to make it appear that it wasn't. With respect to harmlessness, the really big factor here is that the state tried, through McMillan, tried to act as though Mr. Wabuyabo changed his story. And why that's important is because you then can tell the jury but the juries think that he was lying and being deceptive throughout all of this. And the reality was he wasn't during any of this. He maintained.
Now, who's Mr. Dunn? Whose fault is that the jury was misinformed about your client's statements during the interview?
That he was misinformed? I believe they were misled.
That the jury was misinformed. What you just said and what you say in your brief is that in relating those statements, McMillan made it appear that Mr. Wabuyabo's statements somehow changed throughout the interrogation, when in reality, he consistently maintained he did not harm his son.
Correct.
Now, I've reviewed the detective's testimony, and you're absolutely correct. That was the impression the detective gave. But whose fault is that?
If you're getting at the fact that defense counsel argued this, I think that is ultimately, he was doing what we would call damage control based upon what the testimony was and what had come out earlier.
Well,
had the statement never come in at all, there wouldn't have been a need for that damage control.
But if the statement had come in with redactions or with the transcript, the jury would have been fully advised that your client didn't necessarily change his story over time. He was rather consistent about it.
It was my
And the reason the jury was misinformed is because defense counsel made a mistake by not agreeing to admitting a redacted version of that interview or a transcript, a redacted transcript. He should have objected to the detective's mischaracterization, is what I'm saying. And that's not the fault of the interview coming in. That's the fault of keeping out the stuff that we would normally redact in these cases. We do it all the time.
Okay, sorry, I was trying. This format makes it a little difficult to figure out. I didn't want to interrupt you there.
I'm done.
How I will respond to that is, yes, it is possible that a redaction could have minimized some of this problem. Our position is none of it should have come in at all. It was all irreparably tainted, because if you had redacted everything, all of the misconduct in this case, you still end up with Mr. Wabuyabo saying, I accept responsibility. That's what the state wanted in, and that's what the state did get in. This should never have come in at all. Because even without context at all, and I think what defense counsel, perhaps it was a tactical error, but I think defense counsel's intent was to try and point out that it wasn't a straight up admission by saying I accept responsibility, because that was how McMillan tried to say it on the stand was, at the end he accepted responsibility, and leaving an inference of he accepted responsibility and in this abusive head trauma. That's what he was admitting to and accepting responsibility for. But that wasn't what he was accepting responsibility for at all. He was just saying, I was the parent. His statement was, I was the parent that was there. I was the one who was responsible. Therefore, it's my responsibility. And that was what McMillan had actually led on to in his direct testimony, I believe. It was inartfully done. I will fully acknowledge that. But our bottom line is, it shouldn't have come in, any of it. It shouldn't have been, there's no way to redact out all of this, because ultimately all this misconduct led to the statement which the state would use. And if you redact it all out, all the misconduct out, you still have that ultimate statement, which should never have come in, for both the reason it was a custodial interrogation without Miranda rights, and the fact that it was involuntary.
Counsel, I've allowed you to exceed your time, but I'll give you a minute to wrap up for this part of your argument.
Okay, I just wanted to touch on, briefly wrapping up on the involuntariness issue. As far as all of those factors, the biggest things I would like to again highlight is, and I would rest on the arguments in the brief, otherwise, unless I'd respond to the state. But the threats up to his children were perhaps the worst parts of this. Yes, it's bad to curse at someone, to lie to them, and to tell them your version of the truth is the only version of the truth that's going to help things, help you get your kids back, help your kids go to your children, help you reunite kids. So all of these factors, though, all came together, rendered this a coercive interview, making his statements involuntary, and therefore the admission of them was unconstitutional, and it was a custodial interrogation that required Miranda. Thank you.
Thank you, counsel. Mr. Cott, I'll give you this chance to start your argument since you are the appellee.
Thank you, Your Honor, and may it please the court. I'll start with the custodial interrogation issue. As Mr. Dunn has identified, the state does indeed concede that this was an interrogation. So analyzing this issue will turn on the question about whether Mr. Wabuyabo was indeed in custody. The Morton or Lewis factors, which are not exclusive, but have been used by courts consistently, are the 8 factors we analyze and that Mr. Dunn analyzes in his brief.
Well, let me ask you a question about the interrogation aspect in custodial. He was arrested within 45 minutes of this, the conclusion of the interview. interrogation. Is there a reason why there was a rush to arrest him, or they didn't wait for a day or later in the afternoon?
Your Honor, I don't have any information about why the arrest took place 45 minutes later or a day later. I would say as it comes to this court analyzing that factor, I think in sort of the same vein that Mr. Dunn would argue that, well, you arrest him 45 minutes later, which proves this is all a show. I think if they wait 1 or 2 days and they don't have any new facts, they'd say, well, this is also just a show that you waited 1 or 2 days to do this. So I think it kind of sets up a heads we win, tails we lose situation, which is why we'd ask the court not to look at the factor or at least expand it to how much time do you have to wait to arrest? Because that one Morton factor has normally just been, does the person get to leave and are they arrested then? Now, since the...
Have you been into the Overland Park Police Department?
Your Honor, I don't believe I have. It's possible I have.
I'm sorry. I get those communities in Kansas City confused. But so you know nothing of its size.
So, Your Honor, as it pertains to the Olathe Police Department, I've been inside for a few seconds. I can kind of tell you the general layout since it's right down the street from where I'm arguing today. But I couldn't tell you about the exact specifications of the double door area that Mr. Wabuyabo was sent back to because I've never been in that part of that building.
Thank you.
We think it is very important, though, and kind of frames the whole interrogation, those 19 seconds, as Mr. Dunn mentions. Now, he describes them as magic words, and we would agree that the magic words couldn't cure everything, and certainly some interrogations, regardless of the first 19 or 30 seconds, could become so poisoned after that what you say at the beginning does not matter. But in this case, what he says at the beginning should be given very strong weight. Detective McMillan says, "You're not under arrest. You are here voluntarily. You'll be leaving on your own, and you do not have to speak to me if you do not want to." Mr. Wabuyabo also apparently understands this because he makes the definitive statement, "I'm ready to answer anything." He has his cell phone on the table in front of him during the entire interview.
Well, counsel, let me ask you another question then. There's no dispute that he's a native of Kenya. Was there an obligation for the detective to have a qualified interpreter present?
Your Honor, I don't believe there is in this case where it is apparent that Mr. Wabuyabo speaks very strong English, and so I don't think it's necessary in that circumstance. I think at some level, it can sort of become insulting if somebody's very fluent in English, understands what's going on, can answer everyone's questions, to tell someone just because English isn't their first language, you need an interpreter here. Now, I agree that law enforcement should be very careful since it's important that their rights are apprised. But in this situation, watching that interview, there's no time where Mr. Wabuyabo asks him to repeat anything. There's no time where he says you're going too fast, or where Mr. Wabuyabo cannot clearly explain his thoughts. So while I would agree that law enforcement should be very careful if there's any question whether someone is fluent and can speak English, this gentleman is very intelligent and he spoke English fluently, and that's apparent throughout the 2-hour interview. We think, though, that it's also important that this interview only has one officer throughout almost all of it. Now, there is a second officer for a brief moment with the PBT at the end, but it is just one officer with no weapon drawn, sitting at a table near him in a cool office room. That does not overwhelm someone's will like the custodial interrogation framework that sets up Miranda versus Arizona. There are no actual physical constraints. There are no handcuffs. There is no gun drawn. Well, the brief for Mr. Dunn mentions that he had his handgun on him and the Detective McMillan had a handgun on his side. Law enforcement officers carry handguns. In America, for better or worse, many people are armed, but that handgun is never drawn. There's never any motion towards it. There's never any thought that that gun would be used against Mr. Wabuyabo in a small conference room between two people discussing something.
Counsel, I'm more concerned about the manner in which this 2-hour interrogation occurred. Are you aware of any cases that our court has had with regard to whether or not it's permissible to mention to a person that you're interviewing that you need to cooperate or you need to tell the truth, or you could lose custody of your child, or there could be ramifications to your ability to have care, custody, and control of your child?
Sure. And Your Honor, I think it kind of depends on how totalizing that gets viewed as. There's a 2020 unpublished case that came out in February called State versus Boyle. And I'm trying to make sure I have the site because I think I had written it down. And I will.
No, I've got that. And I think Judge Green was on that case. So we'll have that side.
Excellent. And I think that case goes through and discusses kind of all of the cases that have occurred about child custody and what gets mentioned. I would agree that if the court interprets that case and the holdings from those cases to say, you know what, we just have a bright line rule that if you really get into mentioning children at all, that's error. Statements aren't voluntary. We are out of luck. And I will argue harmlessness, which I plan to do anyway during this argument. I think there is a piece of Boyle, though, that discusses that 2007 case that's mentioned by Mr. Dunn that talks about the problem with that case is that the Child Resource Services mention ahead of time that they want him to speak with the police, and he goes there. So it's a question of, does that set up the interview later on? The reason I could give for why I think any mention of children should not view the interview as fatal in and of itself is because these are whole factor tests where you look at everything else. So I don't think it is necessarily fatal in this case, that is just one factor. I certainly agree that's one factor that weighs against us. And this court might determine, hey, we think that mentioning children at all is just so overwhelming that we're going to say that that's too bad. That might be the case. I don't think there is definitive case law that's had to make that determination yet. So I think it is still an open question. The reason we think that question should not be closed for the state in interviews like this is because it is but one factor. It's mentioned for a few minutes. And in a case like this, Mr. Wabuyabo does not immediately say, okay, I shook my baby. I want to make sure my wife Rose can have our children, or I want to have my kids back. I'll admit to everything. So his freedom was not overwhelmed or overborne. As this court has mentioned, he does not confess to the crime. He says he accepts responsibility. So I think that's evidence that at least in this case, his freedom and kind of wherewithal was not so overwhelmed that even if we're very concerned about the mention of his children and about whether he'll have custody in the future or whether Rose will have custody in the future, his voluntariness was not so overwhelmed that it precludes a finding that his statements were still voluntary.
Well, didn't he say more than once that let me accept for my children?
He said, let me accept responsibility. I think the kind of question
But
that
didn't he tie on to that? Let me accept for my children.
yes, and Your Honor, I think that leads to a question about what does for my children modify. Some of the question here, based on the detective's line of questioning, is about for your children, you need to make sure that we have the information we need so we can treat baby Bradley. So it's questionable based on that statement. Is that about treating baby Bradley? Is that why he's accepting? Or is he accepting because the father of the household, he needs to show that he accepts responsibility when something goes wrong, when he's the only parent there? So that statement is a little bit ambiguous about who is he accepting responsibility for. I do think it's a fair reading to at least wonder, is he accepting it because he's fearful of losing custody based only on that statement? So I think
didn't the officer allude that if he didn't confess, that the mother would not get the children back too?
and I think we cited in our brief from 9:35:20 to 9:36. There's about 40 seconds there. And I think he does mention about custody. And if you want your children to at least be reunited with your wife, the only way for that to happen is for you to accept responsibility and tell me the truth about what happened. So that's what he says there, Your Honor.
So why didn't the officer just read the Miranda rights? He essentially did part of them. Why didn't he just do that? Was there anything in the record that said why he chose not to?
Your Honor, I don't see anything in the record that says why he didn't. Honestly, I wish he had, because then we wouldn't be here on that issue today, and maybe not on any issue today. I think that would have been the better practice, but we don't think that is constitutionally mandated. So that's the only issue. I think best practice, read the Miranda rights in a case like this, especially when the interview goes like this, because clearly it's not a slam dunk, even under our argument. We think the factors weigh in our favor, but we wish he would have read them. Sure.
Counsel, I want to make sure that we get in. Before your time expires, I want you to give us the best case you can that if there was error in either the Miranda or the voluntariness issues, that it was harmless.
Thank you, Your Honor. I think two things frame this issue. Number one is the jury convicted on recklessness and not on knowledge based on coming back on the lesser included offense, which means the statement, I accept responsibility, did not frame the jury's argument because they didn't say he knew and did this. They said there was a substantial and unjustifiable risk, and he consciously disregarded that. That culpable mental state means there is not the same heightened requirement for knowledge. The second thing, though, is even if the court gets uncomfortable reading into jury deliberations based on accepting a lesser verdict form and not the higher one, because that sometimes can be difficult, I agree, but it would be one thing to consider. The other very important fact is that the defense was totalizing. Closing arguments from Ms. Lawson, she says that Edna is the child who caused these injuries. They don't deny the injuries occurred. They don't deny the injuries that occurred to Bradley were great bodily harm. It is a question about whether it was Mr. Wabuyabo or whether it was Edna, the 4-year-old. Now, Dr. Jennifer Hansen's testimony is the overwhelming testimony here. The jury even asked for a readback of that testimony. Dr. Hansen says a 4-year-old could not have caused this acute injury that occurred, what is now used to be referred to as shaken baby syndrome. She says that a 4-year-old does not have the fine motor skills to have caused those injuries to baby Bradley. And so that testimony is really what's key here, that she basically says it has to be someone who is an adult. She mentions that because baby Bradley is only 8 weeks old, he couldn't have caused these injuries crawling to himself. And so really this case came down to, was Dr. Jennifer Hansen credible? Once she was credible and the defense presented no expert, that was the overwhelming question, not the question of Mr. Wabuyabo accepting responsibility. If the state had charged an intentional crime and the jury had come back on intentional, I would be in a much worse place today arguing that didn't impact the jury. Because it is reckless.
Let me ask you this, though, that if the interview and the father's recitation of what happened, cradling the baby, etc., was not heard by the jury, the only thing they would have known is that he was with the child. Dr. Hansen obviously thought that an adult would have to have committed these injuries, but would the jury have had any understanding of any interaction between the father and the child prior to the injuries being occurred?
Yes, Your Honor. I think there are two ways they would have known that. First is Rose's testimony, his wife. She says that the children weren't allowed to play alone with baby Bradley. She even mentions that their younger daughter, Edna, because she had snuck in one time. This was an argument the defense made for the Edna theory of the case. But that's a reason the children wouldn't have been alone with baby Bradley. So that'd be another reason. It would have to be Mr. Wabuyabo, who would have been in there with him. And the second reason is the testimony of Detective Thompson. He mentions that Bradley was not allowed to play unsupervised, not allowed to play with other kids. So I would agree with you, Your Honor, that there wouldn't be testimony necessarily about him cradling the child, but it would set up that only Mr. Wabuyabo would have been the person who would have had an interaction with Bradley. And given that Dr. Jennifer Hansen's testimony is that these injuries could not have just been caused by the baby falling down, given how the hemorrhaging happened, given how there were retinal problems, given the injuries to the child, it has to be somebody. And given we've defeated all the other alternative explanations, that would lead to the reasonable inference that it is Mr. Wabuyabo.
I guess what troubles me is I think there's a lot in that interview that is very problematic and is very incriminating, that has nothing to do with, obviously, he didn't admit he committed the crime. He accepted responsibility for it, which I think the jury could understand is any parent that would have a bad thing happen would accept responsibility. But you've got the issues where he actually admits to some kind of shaking of the child. Now it's more minimal than what the doctor said would be required. He suggested that maybe the baby had done it to himself. Now a jury sitting there listening to that is going to say, what in the world is going on? That everyone knows a 2-month-old baby is not going to be able to crawl away and fall out of the crib. And he makes these statements about, no, my child's not getting treatment at the hospital, he's being evaluated. Well, the child had a subdural hematoma, and they knew that within minutes of hitting the doors of the emergency room. So all of this interview information that the detective presented through this interview was very damaging to Mr. Dunn's client, even though he didn't actually admit to causing the damage.
Your Honor, as it pertains to that, I certainly agree there are problematic aspects of this interview. The one thing I think the court could draw there, however, when it pertains to did I cause the injuries by following the Kenyan tradition of shaving my baby's head, or did he cause the injuries by crawling, is that happens so early in the interview that it's before the profanity, it's before the 35 minutes into the interview where he discusses the loss of the kids. So I think one way the court could still view this interview is to say, at that part of the interview, it was still voluntary. What starts happening about 20 to 30 minutes in, where he starts using the word bullshit, where he starts talking about the kids. That's where we think it's error. So those statements still could have come in because they occur beforehand. So those come out before the really troubling parts of the interview that members of this court have identified. So I think that's still a way that if the court is deeply troubled and feels like harmlessness would not survive, those statements are still voluntary.
Thank you.
Yeah, thank you. If there are no additional questions, I think I'm about out of time. And so I'll submit on issue 3 as well.
Thank you, counsel. Mr. Dunn, your chance for rebuttal.
First, a point of clarification. It sounded like counsel was talking about a Boyle case that was unpublished. I'm just to clarify, is that Barlow, the unpublished 2020 case he's speaking of? If so, I'd like to distinguish that. I just am unsure what the court was.
I think it's the case where the fire marshal came in on an arson and mentioned a child and losing your children.
That was Bolin. Yeah. Okay. I thought he mentioned a 2020 unpublished case, and I was trying to rapidly find something that happened this year, and the closest I could find was Barlow, which was a case where the authorities said it was a sexual misconduct case. The authorities said if your daughter or the victim was lying, this is going to affect her future, getting into college, yada, yada. And the court said, well, you're not making threats about her future is not the same as having to make a choice between your right to self-incrimination versus your right as to make decisions as a parent regarding custody and control of the kids' lives. That's not what we have here at all. This was a direct custodial. They're not going to ever be reunited. They're not going to go back to their mom even situation. So Barlow is inapplicable if that was what counsel was referring to. With respect to harmless error, counsel relies heavily on, oh, well, the doctor testified to this and that it couldn't have been this way. This is the way it had to be. And counsel forgets that the juries don't have to believe even experts. We could go back to State v. Narramore in that case that actually got reversed. It's one of the few sufficiency of the evidence cases that were reversed on appeal, where all the experts said that the defendant in that case was not responsible for the death in that case, yet the jury chose not to accept those and still convicted him. Juries do strange things. They don't have to believe everyone. And when you start to say you believe this witness and you're taking this and you ignore someone else, you're starting to weigh facts, which is absolutely not the role of this court. That is the role of juries, and that should not come into harmless error analysis as to who you believe and who you don't. There was a theory presented regarding two things that were relevant to the ultimate conviction of reckless aggravated battery. First, jury could have found that Mr. Wabuyabo did not intend, that he actually did what the state's theory was, but he didn't intend for the results and therefore it was reckless. That's possible. The other possibility is that the jury bought into this theory that the 4-year-old Edna was responsible based upon things. They could have chose to believe this. I do strange things when I write briefs. When I write my facts, I like to give them to my wife, who is a school teacher. She has nothing to do with the law, just so that I can be sure that my writing makes sense to people. And my wife, upon reading it, was, well, that is a possibility. So a jury, a lay juror, would think of things like that. We don't know who they choose to believe and who they don't. And if that's the case, we can't say that it was harmless, that this really damaging, these statements came in. Were you, Judge Boozer, did you have a question?
No.
Oh, sorry, I saw your highlight up there. The last thing I wanted to touch on was the state talking about language and that, oh, there was no reason to believe he wasn't fluent. Law enforcement has a statutory obligation when someone's primary language is not English to provide an interpreter. I don't know why that statute exists. It doesn't talk about someone being fluent in English. It talks about their primary language. Detective McMillan knew that Mr. Wabuyabo was a Kenyan immigrant. I think it's common knowledge that English is not the primary language of most Kenyans. They may speak English, but it is not their primary language. KSA 754351 therefore required an interpreter. Saying, oh, he was fluent enough, he was okay, that isn't the test for that. And we have that statute for a reason, because these things affect whether or not someone's statements, people are less comfortable speaking in when things are not their primary language. This affects the voluntariness of someone's, what someone's statements are to police. So we don't believe that this was some insignificant thing that can just be blown over by saying, well, he spoke some English and he appeared to understand things. This is a factor that definitely goes into the voluntariness of his statements. Running through my notes, again, statements about what Rose may have said or what Officer Thompson may have said. Again, these go to weighing the evidence, who the state wants you to believe. And again, that's improper. This court is not a court of fact, an evidentiary court of fact. This court has to look at what happened below. So because it was disputed below, and clearly Mr. Wabuyabo had different theories as to what happened below, this error was not harmless. Both of these were errors. This was a custodial interrogation, and McMillan's comments and statements and conduct during the interview rendered Mr. Wabuyabo's statements involuntary. Therefore, the district court erred in refusing to suppress them. His conviction must be reversed, and we ask the case be remanded for a new trial.
Thank you, counsel. We will take the matter under advisement. Historically, we get our decisions done within 60 days, and we'll do our best to maintain that schedule. With that, this session of the Kansas Court of Appeals is adjourned. Have a good day.